Good afternoon. My name is Nasheia Conway, and I want to welcome you all for this week's Table Talk Thursday. For this week's Table Talk Thursday, I will be discussing what is mediation. So without further ado, we'll get right into the presentation. And if you have any questions at the end of the presentation, feel free to contact our office to request a one-on-one consultation. All right, so now I'm going to do the shared screen, and then we will get right into the presentation. Bear with me 1 second. All right, so again, my name is Nasheia Conway. I am a staff attorney with Community Legal Services of Prince George's County, where it is our mission to educate, inform, and empower the public as it relates to their legal needs. So again, in this presentation, I will be discussing family mediation. Family law is just one of our many legal services that we do provide to the community. We also provide other areas of legal services as well, such as foreclosure and bankruptcy, landlord and tenant, domestic violence, and other civil matters as well. I would encourage you all to visit our website for more information or give us a call. So without further ado, let's get into this week's presentation. So what is family mediation? Mediation is a process in which a trained, impartial person, the mediator, helps people in a dispute communicate, understand each other, and reach an agreement if possible. So it's really important that I note here that a mediator is not a lawyer. Well, a mediator can be a lawyer, but the role of the mediator is not to give legal advice, but to more so help facilitate the conversation and the dialogue between the two parties. Family mediation is the mediation of disputes and actions for divorce, annulment, paternity, child custody or visitation, child support, or alimony. Mediation can be used to resolve the entire range of family disputes, either court proceedings or afterwards, such as continuing disputes from a custody agreement, such as a modification if necessary. What is court-ordered mediation? The court may order mediation in custody and or visitation cases. In most cases that involve contested custody or visitation matters, the parties are referred to mediation if there is no allegation of domestic abuse. The court will designate a mediator from a list of qualified mediators. The court may require the parties to attend a maximum of 4 hours of mediation, if not more than 2 sessions. However, the mediator may recommend to the court to order an additional 4 hours if necessary. So let's talk about some of the advantages of mediation. So mediation can help facilitate a better co-parenting relationship, meaning that if the two parties can try to resolve the issues that are in dispute in mediation, it could it could provide a better impact, a better relationship for the co-parents going forward, because you're still going to have to co-parent with this person. And if you can get the issues resolved in a less aggressive manner, then that will be better. That would be what's in the best interest of the children. It can also help to preserve that co-parenting relationship going forward. Mediation is confidential. Litigation is public. So in mediation, there may be some private things that come out that you may not necessarily want to come out in a court proceeding where the public may have access to those proceedings. And although right now, some litigation is a little more private because things are being held via Zoom, still mediation provides that atmosphere for a place where your sensitive information will be a little bit more confidential. Mediation is not as lengthy as litigation. So litigation can last a long time, months, even years sometimes. And mediation is a lot shorter. So that's another advantage of mediation. Mediation is also less expensive than litigation. Litigation can become very costly very quickly, and mediation is less expensive than having to go the route of litigation. Also, the parties have more control of the outcome. So in mediation, the parties do have more control of the outcome versus going to court, and the parties don't really have any control over the outcome at that point. At that point in time, the decision is really up to the magistrate or the judge. Should I have an attorney? It is helpful for parties to have an attorney, whether or not the attorney participates in the mediation sessions. Parties will be advised by the mediator to seek advice from their attorneys, and it is recommended that an attorney review the final settlement agreement. Mediators, again, may not give legal advice to the parties. So I mentioned earlier in the presentation, a mediator can be a lawyer, but when that lawyer is serving in the role of as a mediator, that lawyer cannot give legal advice because they are serving as a mediator. They're supposed to be neutral and impartial. What happens if we can't agree? If you don't reach an agreement, you can still go to court. You do not give up your right to litigate your dispute just by going to mediation. What occurred in mediation is confidential, again, and it is not admissible in court or through discovery. In a court-ordered mediation, the case will return to the court for decision by the magistrate or judge if the two parties cannot reach an agreement. Is the agreement binding? A mediated agreement, which is signed by the parties, is a contract and as such is binding. Some mediated agreements are incorporated as parts of the parties' court order. So if you would like to read more information, if you want to learn more about mediation and family mediation in a custody or maybe a divorce action, I would encourage you to visit this website at peopleslaw.org. They have a lot of helpful information on there. That's where I got the information for today's presentation from. So I would encourage you to go to that website to read more information about family mediation. So I want to thank you all for tuning in to this week's Table Talk. And I would encourage you all to come back next Thursday for our next week's Table Talk. Until then, I hope you enjoy the rest of your day and take care. Bye-bye.